Have you ever been, sitting somewhere, maybe signing important papers, like a lease or something, and someone says, okay, we just need a notary for this?
Mm-hmm. Happens all the time.
Right. And most of us just nod, thinking, yeah, okay, a notary, someone with a stamp. But have you ever actually stopped to think about what that stamp and the person using it really means?
It's definitely more involved than just, applying some ink. It's a really fundamental legal safeguard, often working quietly, but it's absolutely critical.
Exactly. And well, that's what we're doing today. We're doing a deep dive into this surprisingly complex and really vital world of Arizona Notary's Public. Our goal is to pull out the key info, demystify the role, and uncover what's really going on beneath that stamp. Basically, view a shortcut to being well informed.
Yeah, and for this, we're going straight to the source. We're using the official Arizona Notary Public Reference Manual. This is the guide direct from the Arizona Secretary of State's office. It's the gold standard for how things work in Arizona.
So why should you care about this? Well, maybe you're signing a lease soon, or a will, getting a loan, or maybe you're even thinking about becoming a notary yourself. Understanding this role is honestly key to protecting yourself, stopping fraud, and just making sure your important documents are legally sound. Let's unpack this. Okay, so to really get the significance of that notary stamp, we have to start with the basics. Who is an Arizona notary public? Because it sounds maybe like a small administrative thing, but the manual is super clear it's not just some casual side job.
Oh, definitely not.
Yeah.
The core definition is pretty powerful. An Arizona Notary Public is actually a public officer. They're commissioned by the Secretary of State. And the absolute most important thing to get, their main job is to be an impartial witness. No conflict of interest, period. That's not just a guideline. It's like the foundation of everything they do.
Impartial witness. Yeah, that phrase definitely carries weight. So why do we even need them? What's the basic why behind notarization? Why can't I just sign something myself?
Well, think about it. Government offices, businesses, the public, they all rely on documents being accurate and having integrity. So the main reason for notarization is really to deter fraud and to prove that a signature is authentic. When something's notarized, it means the notary took reasonable, required steps to check the signer's ID before they attested to that signature. It adds this layer of verifiable trust.
Okay, so it's about trust and verification. Makes sense. And that impartiality thing, it runs pretty deep, doesn't it? The manual has some, frankly, surprising rules about it.
It really does. A notary cannot have any financial or beneficial interest in the transaction, and they mean any, no matter how small. If the notary or even their spouse is a party to the document or stands to gain directly from it, that notarial act becomes voidable. That means it could be legally challenged and potentially thrown out later.
Wow. Okay, what about family members? That seems like a situation where impartiality might get tricky. I could see myself asking my cousin or something.
Yeah, that's a really common question, and the manual gives some clear advice. While it might not be strictly illegal in every single instance, notarizing for any family member is really, really discouraged. Why? Because like you said, it could call into question a notary's impartiality. And actually, lots of courts have found that these kinds of family ties do imply a financial or beneficial interest. So the safest bet, just say no and point them to someone else.
That makes total sense. Avoid even the look of a conflict. Now, there's a little nuance, right, for corporate notaries. Can someone who works at a company notarize documents for that company?
Generally, yes, they can. If a notary is a stockholder, director, officer, or employee of a corporation, they can notarize for that corporation. But, and this is a big but, it becomes unlawful and voidable if the notary themselves is a named party in the record, either as an individual or as the direct representative of the company in that specific deal. If they're personally involved like that, their impartiality is compromised.
Okay, so it's crystal clear that becoming a notary isn't just, filling out a form. What does it actually take in Arizona? What are the main qualifications?
First off, residency. You have to live in Arizona, claim it as your primary residence for tax purposes. Just being here temporarily doesn't cut it. You also have to be a U.S. citizen or a legal permanent resident.
Any exceptions or special rules for military folks?
Yes, there are. Commissioned officers in the U.S. military actually have a federal commission that lets them perform notary acts for other service members and their families. But non-commissioned officers wanting to be an Arizona notary for the general public, they still need to meet all the standard Arizona requirements we just mentioned.
Now, here's something pretty big, especially for newcomers. The exam. I hear this is a relatively new requirement.
That's a huge point, yeah. Starting July 1st, 2025, all Arizona notaries, new applicants, and those renewing, have to pass a notary exam. It'll be offered at Prometric test sites, And they're planning remote options too, which is good. And besides the exam, notaries are absolutely required to keep an approved reference manual handy, like the one we're digging into now that details all their duties, authority, and ethical stuff. It's basically their rulebook.
Okay, so you passed the exam, you've got your manual. What's the actual application process like? Any common mistakes people make that mess things up?
The key things you need are the signed application form, a surety bond with original signatures, no copies, and the processing fee. And another critical change, also starting July 1st, 2025. The application, the bond, and the fee must all be submitted together. They won't process it otherwise. It seems small, but missing that combined submission can really hold things up.
A surety bond. Remind me, what's that for exactly?
All right, so the bond in Arizona, it's a $5,000 surety bond. Its main job is to protect the public, the people the notary is doing notarizations for. It has to come from an Arizona licensed surety company and cover the whole 4-year term of the commission. It's like insurance against notary mistakes or misconduct. Timing-wise, once they get everything, it usually takes about 4 to 6 weeks to process, assuming no mistakes.
And what kind of mistakes usually cause rejections or delays?
The manual highlights things like names or signatures not matching perfectly between the bond and the application, or maybe the bond dates are wrong. Those kinds of things often need a rider, which is like an official correction from the bonding company, and that just adds delay. Also, there's a $25 application fee to the state, plus costs for your seal and journal. But it's important to remember, the manual says payment of fees does not constitute ownership of a notary public's commission. You're paying for the permission to serve, not buying the title.
That's a really important distinction. What if a notary moves house?
If you tell the Secretary of State within 30 days, there's no charge. But if you wait longer than 30 days, there's a $25 penalty. And refunds, they only give those for duplicate applications, not really for any other reason.
So you get commissioned. How do you keep that commission active? And importantly, what kinds of things can get a notary into serious trouble?
Okay, so the commission lasts for 4 years, and it's strictly non-transferable. You can't give it to someone else, and you can't take it with you if you move out of state. The Secretary of State has the authority to deny, refuse renewal, revoke, suspend, or even put conditions on a commission if there's any act or omission showing a lack of honesty, integrity, competence, or reliability.
That sounds pretty broad. Can you give some specific examples? What actions really land a notary in hot water?
Sure. Things like failing to keep the required journal or not getting an official seal, using false or misleading advertising. And here's a huge one. Charging more than the fees allowed by law. If a notary overcharges, they're liable for 4 times the illegal fee, and they're guilty of a Class 5 felony.
Wow, a felony. That's serious.
It really is.
Yeah.
Other big no-nos include any kind of fraud or deception, like letting someone else use your seal, failing to properly identify a signer using satisfactory evidence, or not responding if the Secretary of State launches an investigation. That felony charge for overcharging really shows how seriously the state takes protecting the public from notary misconduct.
Yeah, that felony charge definitely hammers home the responsibility. Okay, let's switch gears to the tools, the actual physical things. The official seal and the journal. What are the rules around those?
The official seal is absolutely essential. It has to show notary public, the county name, the notary's name exactly as it appears on their commission, and the date the commission expires. You can use an embosser, but only if you also use a rubber stamp seal with it. And critically, you can't stamp over your signature or anyone else's signature on the document. Everything needs to stay clear.
And the journal. Is that just like a good idea or is it mandatory?
Oh, it's mandatory. Absolutely. Notaries have to keep a journal for every single notarial act. There's one tiny exception for court reporters doing work in actual judicial proceedings, but for everyone else, you log everything. And you have to keep that journal for at least 5 years. If you stop being a notary and all the entries are 5 years old or older, then you can destroy it. If not, you have to send it to the Secretary of State using certified mail or some other method that gives you proof they got it.
What exactly needs to be written down in that journal for each act?
It's pretty detailed. Each entry must include the date, a description of the document and what type of notarial act it was, like an acknowledgement or a jurat, the printed full name, address, and signature of the person you're doing it for, what kind of ID you use to verify them, including a description of the ID and its expiration date, and finally, the fee you charged. It's meant to be a complete record.
I saw something interesting about personal knowledge in the journal. Can you explain that little wrinkle?
Right. So if a notary personally knows the signer, meaning they know them well enough through past dealings to be reasonably certain it's them, and the notary keeps a copy, paper or electronic, of the actual document they notarized, then technically, under the law, a separate journal entry isn't strictly required for that specific act. However, the manual strongly recommends making a journal entry anyway, just for best practice. But if you don't personally know the signer, a journal entry is absolutely mandatory, no question. And another key rule: journals cannot be shared. It's your individual professional record.
Are those journal entries public information?
Mostly, yes. Journal entries generally fall under public records laws. But there's one very important exception. Any entry related to parental consent for abortion is kept confidential. Because of this, notaries can choose to keep two separate journals if they handle both public and confidential types of notarizations, just to keep things clearly separated.
Okay, so it sounds like sometimes a notary has the right to just say no. When can they refuse to perform a notarial act?
They may refuse if they aren't convinced the person is competent or has the mental capacity to understand what they're signing, or if it seems like the signature isn't being made knowingly and voluntarily. But they must refuse. It's not optional if the signer isn't physically there in front of them, or if they can't meet the identity standards, personal knowledge, credible witness, or proper ID, or if the ID looks fake. It's a really important check against potential fraud.
And what should they do if they refuse?
Manual strongly advises that notaries document every refusal in their journal. Note down why they refused. This protects the notary if there's ever a legal question later. Oh, and interestingly, the fact that a document is handwritten is not a valid reason to refuse.
That's a lot of power and judgment involved. So what are the absolute limits? What can a notary definitively not do?
Big one. A notary commission does not give them the right to give legal advice or help draft legal documents. The Secretary of State's office specifically recommends that notaries shouldn't prepare documents that they themselves are then going to notarize. Even if the notary happens to also be a lawyer or a licensed document preparer, doing both preparation and notarization on the same document casts doubt on the impartiality of the whole thing.
What about that term notario publico? I've heard that can be confusing.
Exactly. It's a major point of caution. Notaries who are not licensed attorneys in Arizona cannot advertise using notario or notario publico. In many Spanish-speaking countries, that term implies the person is an attorney or has legal authority. So to prevent confusion and potential unauthorized practice of law, if a non-attorney notary advertises their services at all in any format, they must include a very specific, prominent disclaimer. It has to say, I am not an attorney licensed to practice law in this state. I am not allowed to draft legal records, give advice on legal matters, and so on.
Got it. And one last thing on limits. What about those international documents, things like apostilles or certificates of authentication? Do notaries handle those?
No,
Yeah,
absolutely not. Notaries cannot issue apostilles or certificates of authentication. Those are specialized certifications needed for documents going to foreign countries, especially countries that are part of the Hague Convention. That's an international agreement simplifying document authentication. Only the Arizona Secretary of State's office can issue those. A copy certification, which a notary can sometimes do, is totally different.
That's super helpful context, really drawing the line between a notary and other legal roles. Okay, we've covered the who and the what. Let's get into the how, the actual nitty-gritty of performing these notarial acts. What's step one?
The absolute #1 non-negotiable rule for any traditional notarial act. The signer must appear in the notary's physical presence, no ifs, ands, or buts. If they're not there, the notary has to refuse. That's the only way the notary can properly ID them and witness the act.
Physical presence. Okay. No video calls for the standard stuff. Once the signer is there, how does the notary actually confirm it's them? What are those 3 pillars of ID verification?
Right, the manual lays out 3 main ways. First is personal knowledge. This means the notary knows the person well from previous interactions, enough to be reasonably sure it's them. Second is satisfactory evidence of identity. This means specific types of unexpired government-issued ID cards. Think U.S. passport, state driver's license or non-operating ID, military ID. Also includes things like certain inmate IDs or other Department of Homeland Security IDs that prove legal presence. The key is government-issued, current, and reliable.
And the third way?
The third way is using a credible witness. Now, there are 2 scenarios here. One, the notary personally knows the witness, and that witness personally knows the signer. The notary IDs the witness through personal knowledge, then puts the witness under oath to vouch for the signer. 2, the notary doesn't know the witness, but the witness does know the signer. In this case, the witness has to show the notary one of those acceptable government IDs we just talked about, and the witness has to be put under oath. In either scenario, the witness always has to know the signer, and the witness must sign the notary's journal along with the actual signer. And yeah, the manual really pushes notaries to learn how to spot fake IDs.
What if the document is in, say, Spanish and the notary only speaks English? Can they still notarize it?
Surprisingly, yes, they can. A notary is allowed to notarize a document written in a language they don't understand, but the crucial part is the notarial certificate, the part the notary fills out, signs, and stamps. That certificate must be worded and completed in a language the notary reads, writes, and understands, like English. If needed, a translator can be involved, but that translator has to be physically present with the signer and the notary during the whole thing.
Okay, let's quickly break down the main types of notarial acts. They're not all the same. First up, acknowledgement. What's that one about? And when does the signing happen?
An acknowledgement is basically the signer declaring, yes, I signed this document for the reasons stated in it. And here's the key difference. The document could have been signed beforehand, maybe yesterday, maybe an hour ago. But the signer must be physically present before the notary when they make that acknowledgement. The notary's job is to verify the signer's identity and attest that the person standing there is the one whose signature is on the page.
Okay, then there's verification on oath or affirmation, which people often call a jurat. Sounds more formal.
It is. A jurat involves a solemn promise, an oath, or affirmation that the statements written in the document are true. So for a jurat, the signer must be put under oath or affirmation by the notary, and then they must sign the document right there in the notary's presence. Another really important rule for jurats. The document cannot have any blank spaces left in it. It needs to be complete as far as the notary can tell. The manual even gives sample oaths like, I swear or affirm that the contents of this document are true and correct.
And the third main type, copy certification. Seems simple, but I bet there are catches.
You bet. The idea is the notary certifies that a photocopy is a full, true, and accurate copy of an original document they've seen. But the big catch is what they can't copy certify. Notaries in Arizona cannot make certified copies of public records. Things like birth certificates, marriage licenses, court documents, property deeds. If you need a certified copy of one of those, you have to get it directly from the government agency that issued it.
Right. And that final piece, the notarial certificate itself, the stamp and signature part, what are the hard rules for that?
It has to be done contemporaneously, meaning right at the same time as the notarial act itself. It needs the notary's signature, the date. It has to state the jurisdiction, like State of Arizona, County of Maricopa, include the notary's title, Notary Public, and their commission expiration date. It must be in a language the notary understands. The signature has to be their official wet signature, meaning real ink, not a stamp or digital image, and it has to match exactly the name on their commission. And typically, the official stamp goes right next to the signature, usually to the left.
Okay, so we've really covered the traditional notary world, but things are changing fast, right? Let's talk about the future electronic and remote online notarization. These seem like big shifts to modernize things.
Huge shifts. Both electronic notarization and remote online notarization, or RON, officially kicked off in Arizona on July 1st, 2022. They really open up new ways to get documents notarized.
How does the basic electronic notarization work? Is it just signing a PDF?
It's a bit more sophisticated than that. Electronic notarization lets notaries handle electronic documents using special tamper-evident technologies. Often this means using a digital certificate, usually following something called the X.509 standard. That's just a technical format ensuring the document can't be secretly changed after it's electronically signed and sealed. Notaries have to tell the Secretary of State what technology they plan to use and get it approved first. Their electronic seal has all the same info as the rubber stamp, plus their commission number. And just like the physical seal, they're responsible for keeping their electronic signature and seal secure. No sharing allowed.
Okay, now the really futuristic one, remote online notarization, RINN. This lets people get things notarized without being in the same physical room, right? That sounds like a game changer.
It really is. RINN allows a notary, who is physically in Arizona, to notarize documents for someone located anywhere else, could be across the state, across the country, even internationally, using secure audiovisual technology, like a secure video call. But as you can imagine, the biggest challenge and the most complex part is verifying the signer's identity when you can't physically check their ID or see them face-to-face in the traditional way.
Yeah, how do they handle ID verification remotely? That seems tough.
It's definitely multi-layered. If the notary personally knows the signer already, that still works. A credible witness can also be used remotely, as long as everyone can see and hear each other clearly on the call. But if the notary uses a remote credible witness, They have to verify that witness's identity using something called multi-factor authentication.
Okay, but what if the notary doesn't know the signer and there's no credible witness available?
Then they have to use more advanced methods. The law requires at least two different types of high-tech identity proofing. First is credential analysis. This uses technology, usually from a third-party vendor, to scan the signer's ID remotely and check it against various databases for authenticity, looking for signs it might be fake or altered. The second is called Dynamic Knowledge-Based Authentication Assessment, or KBA.
KBA sounds like a quiz.
That's basically what it is. The signer gets asked a series of multiple-choice questions based on information pulled from public and private records, things related to their personal history, like past addresses or credit information, that only they should know. They have to answer a certain number correctly within a short time limit. It's a tough quiz designed to trip up imposters. You usually get 2 tries. It's a pretty robust system designed to make remote ID verification secure.
Wow, that is thorough. Is there a record kept of these remote sessions?
Absolutely. It's mandatory to make an audiovisual recording of the entire RON session from start to finish. Both an electronic journal entry and that full video recording have to be kept securely for at least 5 years. They need to be protected, like with passwords or encryption. And, just like regular journals, they're subject to public records laws. Plus, the notarial certificate for a RON Act has to include a statement making it clear, something like, "This remote online notarization involved the use of communication technology."
So there we have it, a pretty comprehensive deep dive into the surprisingly intricate world of Arizona Notaries Public. We've covered everything from the basics that they're impartial public officers through all the strict rules for getting and keeping a commission, the details about seals and journals, the limits on what they can do, and we even looked at how things are changing with electronic and remote notarization.
Yeah, and understanding all these details really does empower you, the listener. Whether you're the one signing a document, dealing with legal stuff, or just want to understand the safeguards in place. It shows that what looks like just a simple stamp is actually, a really important piece of ensuring integrity in transactions.
What strikes me is how this role, which has ancient roots in verifying who someone is and what they intend, is now right at the cutting edge of digital trust. They're tackling this huge challenge. How do you prove identity and intent when people aren't in the same room? So, thinking about this big shift on, what other changes or maybe even new ethical questions do you think might pop up as technology keeps racing ahead and changing how we authenticate ourselves and our most critical agreements? Something to chew on until our next deep dive.